All right. Hello, everyone. Thank you so much for being here. Today, I'm so glad to be speaking with entertainment lawyer Michael Duboff. I'm Daniela Saioni, and I run a number of screenwriting programs. And for years, people have been requesting that we sit down with an entertainment lawyer who specifically works with screenwriters. Michael's firm, Edwards Creative Law, was highly recommended in Inc. Canada, which is our favorite group on Facebook for screenwriters. And within the firm, they said Michael would be the best person to handle this interview because he specializes in film and TV and works with a lot of independent screenwriters. He's a seasoned Canadian and entertainment industry attorney, deeply embedded in the music, film, and TV spheres. He's from Winnipeg, but his expertise extends throughout Manitoba and Ontario, bridging artistic and corporate worlds. With roots as a musician and film industry professional in major cities like Toronto and Vancouver, he's not just a lawyer, but a passionate advocate for artists. We love that. His diverse background and dedication make him an invaluable ally for the dynamic arts community. And his firm deals with different types of clients who sell projects and option projects of different kinds all over the world. Welcome, welcome, Michael. Is there anything you want to add that I didn't say?
Clear things up a little bit. I'm actually in Toronto now. I live in Toronto. I'm from Winnipeg originally, and I work there quite a bit. My family is there, but my day-to-day is in Toronto. So like many of you I saw, maybe I will see you at the local coffee shop or something like that. But as well, I write a lot actually on the side too. I like to have my creative outlet still, so I do write quite a bit. I got a degree in film production at formerly Ryerson, now TMU. So I have dabbled with some screenwriting as well. I wrote a feature once upon a time, and nowadays I work more so in prose. But not only is writing my profession or the assistance to writers, but I also do enjoy writing. So I'm always happy to have these chats with fellow writers.
Can you tell us a little bit more about your firm and the types of clients that you work with in the screenwriting space specifically?
For sure. So our firm, as mentioned, it's based out of Ottawa, but we have clients across the country, and we're strictly an entertainment law firm. So we only work with people within the industry. A lot of times that comes down to doing commercial work. So even though it's called entertainment law, it's really just like a subset of commercial law, kind of like focused on that specific industry. But as such, we do a lot of commercial work. We do some corporate work too. For those that know about producing, there's production companies that are often required. So we're there to help kind of incorporate and manage those corporations. And then we do some litigation as well when things don't go appropriately or as planned within the industry. But with regards to screenwriters specifically, yeah, myself and many of our other lawyers, we work with independent screenwriters as mentioned. We can work, as early as like an inception of an idea all the way to, working on set as a writer on a production. We work for producers, so independent producers, also production companies, but really any person involved in, the film and television industry, any type of writing setup, a writer, people within writers' rooms as well, like really anyone who touches the pen or keyboard that's associated with film we represent.
What stage should screenwriters seek out a lawyer to work with? At the deal memo for staffing stage, or like when they get a shop around agreement or an option agreement or a deal?
Oh, that's a great question. Really, there's kind of two scenarios that I would say. Firstly is when you get like a contract that comes your way. So if you are hired for production or hired by just anyone to provide writing services, definitely I recommend that you consult with a lawyer just to have it reviewed. If you're experienced and have done this a million times, then maybe you have the expertise at this point. But really, like I highly suggest getting a set of eyes on agreements before you sign it. That's really, really important. I know people like to kind of jump the gun and they're really excited about getting like a job offer. And they'll, sometimes they'll see some zeros or something that really entices them. But it's important to really make sure you have a complete understanding of what you're signing before you move to the next step. The second situation is if you start working with other people. So I think this may be a later question as well, but as soon as you start working with people, even if you don't, you don't necessarily have to consult with the lawyer at that moment, but you need to start thinking about some of the legal considerations. Because at the end of the day, you're creating intellectual property, you're creating a work that has legal implications. And so it's important to start thinking about some of those considerations, which will then likely turn into an agreement of some kind. And again, you can consult with the lawyer along the way there to make sure that you're, thinking of everything and having the right conversations.
I learned some hard lessons in the second scenario in one past partnership where we didn't have an agreement in writing and the project got optioned, and it was very, very expensive and messy to deal with it later. So now I always advise people, like, go see a lawyer first up front, or at least have some kind of an agreement in writing up front, because it'll get way more expensive to do it in retrospect, and it'll get a little nasty too. So
Yeah. Yeah, and again, it's kind of it can be a hard pill to swallow because sometimes you're working with your best friend, you're working with your brother or whoever it is, and you think, you have the best relationship in the world. But unfortunately, things can change when, success is incoming and things can change. And this is all about just having those conversations to make sure that things are clean later down the road. It doesn't need to inherently be, going at each other or like creating a dispute right from the get-go. Is really just making sure that things are cleaner later on.
yeah, and that you agree on things up front so that, yeah, everyone's clear going forward on what they're doing. Oh, can you also sort of let me know? I know in the States, I've been offered shop around deals. Do people do that in Canada? And what's the difference between that and a full option?
Are you referring to like a shopping agreement?
Uh,
So yeah, shopping agreements. So this we'll kind of go into a bit of a more hardcore legal discussion for a moment. But for those that are not fully familiar, option agreements are probably the number one agreement for screenwriters out there. And as a very, very brief overview, an option agreement is essentially like two agreements in one. There's the first part of it where you're granting the rights to shop around the project. So there's an option term for, 12 months or whatever and you're receiving an option fee and you're granting the producer the rights to shop around the project. If the producer wants to move forward, say they've received financing or so on, or they have all the pieces in place, they'll then want to exercise the option. So this moves into the second like part of the agreement, and that will then be the exercise fee or the purchase price, where they pay like the full other amount, and they then actually receive the rights to make the production. So the first is the bundle of rights to market it, to shop it. Second is to actually produce the adaptation. So a shop around agreement is just that first part of it. It doesn't have that second half of it where you actually get the rest of the rights. So, there's that separation. The shop around agreement is just that first half, whereas the option agreement has both halves in one.
Oh, that's so interesting, because I've only been offered, or propositioned about the first half in Los Angeles, but in Canada, it usually goes straight to option talk. So I didn't realize that that one is actually the first half. Yeah, that makes.
It's essentially like they can have more terms added to it, but that's really the essence. And, a little secret is, there's leverage on both sides here, but as screenwriters, technically speaking, like the around agreement is more powerful because, you have that piece where you're shopping around your property. And then once the producer wants to move ahead and actually get those rights, there's no second half yet because it's only that first half. So you actually need to negotiate at that point, but you as the screenwriter, well, they actually want to adapt this now. They want to move forward. So I have more leverage here. So you can bring that to the table when you're negotiating that second half to the agreement, the actual purchase at that point.
Oh, that's interesting. And another like really, really common question I get from brand new writers who may not yet be represented. By the way, like most of the option agreements that have been made from my student body have been made from unrepresented first or second time writers. It's like bonkers. I think that's an excellent thing that's happening in the industry, that more people are getting read and optioned. But it's also kind of terrifying to be the writer in that position if they
For
don't
sure.
have the first part of that question is like, if they don't have an agent, can they use a lawyer like yourself to get material to actors or production companies?
So it's a little bit up in the air. I'm not going to give a complete answer because, what the answer that lawyers love to give is just it depends. Technically speaking, a lawyer shouldn't be doing that as much. Our job at the end of the day is to be providing legal advice. We do have people come to us quite often, and they're looking for us to, connect them to individuals and create business opportunities. And there are lawyers that will do that, but I wouldn't go seeking a lawyer for that specifically. At the same time, there's the whole thing in the industry where the division between an agent and a lawyer can be a bit gray, can be a bit vague. And I find in the US in particular, one can kind of meld into the other even more so. Here, our regulations, like our law society regulations, try to keep us in in our lane, more clearly. There's a lot of agents that come from legal backgrounds too. So again, it just creates that overlap even more. Again, I don't know if that was a complete answer. It depends for us ourselves. Again, we don't take on clients specifically for that role. Like if someone's just coming to us for those business opportunities, we don't do that. But if there's a fit that's like very natural, that's someone we know that like comes to mind, and we have the relationship with the client at that point, we can always introduce people, but we don't market our services for that reason.
Ah, okay. I didn't know that about the differences in law, lawyers and agents in Canada, having that difference in the US. How about in the UK? Do you know? Because we have a lot of UK students.
I'm not too sure. Again, like this is technically speaking, these are different roles, but even some lawyers do actually operate and will act as agents to like on the side or manage people. It all depends on the individual. But really there should be like the separation of roles. It's just things are sometimes looser in other jurisdictions or just based on that individual.
And have you ever had any first-time writers in that position who, let's say, a big production company wanted to make a deal with them? They didn't yet, they were still shopping for an agent. Probably they would get an agent at that point, but in the meantime, could you represent them?
Yeah, absolutely. Yeah. Yeah. Again, what we would be doing, we wouldn't be going out to shop around their work, but when they have a need for legal services, which includes if there's a deal on their plate that they're contemplating, we definitely assist there. And that's a lot of the work that I do is for writers that don't yet have agents or that actually want like a proper legal review of a contract.
Yeah, because as a WGC member, I always feel like I'm protected, but then I realized, no, it doesn't cover everything, right? The WGC basic agreement.
Yeah. Yeah, exactly.
What are some of the deal points that any writer, especially newer writers, because we have a lot of newer writers in my programs, what are some of the deal points that they can that are reasonable, I would say? Because you know how people expect royalties and people expect ownership and people, like what can they realistically, do you think, in this day and age generally bargain for?
Gonna be that same answer. It all depends. Really, at the end of the day, everything is negotiable. So whatever's on the paper, this is the thing that, producers will sometimes try to use is they'll just say, this is how things are done. This is the industry. This is the industry standard, and just kind of say that to kind of close the conversation. But, at the end of the day, everything can be changed. Nothing is, no agreement is built into stone that can't be, revised or amended in some way. So again, it depends on who everything is. What depends what the property is. If, first time writers, sometimes the screenplays are absolutely incredible and, that creates leverage. So they can use that to revise any kind of terms out there. So again, everything is on the table, regardless of what a producer might say.
That's interesting because you know how in Canada the production company does need to have majority ownership to access like telefilm and certain network funds. However, in France, the law is completely different and it remains with the creator. But we saw just now in the news that the director of Sinners, the creator of Sinners, negotiated with Warner Brothers to retain ownership, which is something we
Yeah,
really don't see.
yeah, yeah, absolutely. But yeah, that brings up a good point that sometimes there are limitations based on, the financing of the production or, if it's a treaty or Cavco or something like that, where that will have inherent limitations on what a producer can do. But outside of that, like everything is completely open.
I'm still like I'm excited about the Sinners
Yeah,
scenario. I mean,
yeah,
the industry is going more creator driven and more independent production company driven. It's exciting. Also kind of a little bit uncharted, really, right?
absolutely. Yeah, the studios are afraid.
I have I've worked with every major studio now, not as a writer, but on set. And there's some studios I love, absolutely love working with, and I hope they never die. But I also work with a lot of independent creative voices, and I'm cheering for them too. It's like either way,
Yeah.
I think, we'll figure it out. The industry will shift and we'll all figure it out. Yeah, and I do want to talk about writing teams because we have a lot of writing teams that I mean I'm in a lot of writing teams myself.
Mhm.
Are those boilerplate templates that the WGA provides, are those enough to start, do you think?
They're good for conversation starters, but there's kind of like the added dimension to it that's still like good to figure out and discuss. So, some of the key things that just in general with working with partners that I always bring up, it's decision making, who's the ultimate decision maker in this relationship, or is everything 50-50? If it's 50-50, what happens if you're at an impasse or the vote's at a tie? What happens in that situation? What happens if you work on something together and one of you wants to leave or stop working on it? What happens with the project then? Can the other person carry on with it? Can they bring on another writer? Obviously, there's compensation. How is compensation split, at present and down the road? Again, taking into consideration what happens if someone leaves the project, what happens if just one of them creates a spin-off project. So it's all about relationship and relational kind of questions, and it's what ifs, what happens if this scenario comes up.
I realized in one of my earlier agreements that I made with a writing partner, we didn't have a death clause. Like, what if
Yeah.
he dies? Who gets the right?
Mhm. Exactly. Yeah.
Can we include in contracts like who's in the room for pitching? Is that something you can negotiate with a producer and or with a writing partner?
So yes, the answer is yes. It's just, in a contract, you can only bind the people that are in that contract. So for example, if you're working on your co-writer agreement, yeah, you can agree together that, we want to bring in this person to be in the conversation with us. And that's fine, but you can't force that upon like a producer. For example, once you're in the meeting with them, they might just want to speak with one of you or just with the two actual writers instead of your dad who's your business consultant. They might not want them in the room. I'm sure that'd be fine at the end of the day, but the point is that the contract can only really bind the people that are the parties to the contract.
Oh, that's really important also for credits. Obviously, like producers usually have final say on that, and even they don't because the network or the studio might have final say, right?
Exactly. Yeah. So yeah, that's exactly right. So you can always agree on credits, but then, a lot of agreements will always say it's subject to distributor approval or broadcaster approval and so on. So sometimes you can carry on that obligations through to the next agreement, but you just have to be aware that it's not always going to fly.
What are some of the legal blind spots a lot of writers that come to you have that you've noticed over the years?
Interesting. Um, Blind spots are really, on a general level, is just that they haven't reviewed the agreements carefully, or they don't understand the full implications of what they've signed to. More specifically, one of the big ones just has to do generally with like intellectual property rights. So ownership of their work, what's happened with it, whether it's been transferred to someone else, whether they retain it, and again, those implications of what's happened. There's definitely been cases where I've reviewed agreements that have, like, these are executed agreements that have been entered into, and the client didn't realize that they'd essentially given away all their rights. So, that's a big one. A lot of times, again, people's attention are drawn to like the flashy clauses, like what their compensation is. But they don't look at other clauses. And even with compensation, if it's a percentage of revenue, there's a difference between net and gross. That's a major distinction that people just see like the percentage number and don't understand that, it's based on a calculation. And even then, if you have net or gross, you have to know what the definitions of those are. So the definition of net revenue can vary quite significantly from agreement to agreement.
Yes, I don't know if it's true, but I've heard that if you make a deal on net, and most deals are on net, I've heard, but that you'll never see a penny.
That's the industry in general, I would say.
Yeah, yeah, yeah.
If you're doing any profit participation, it's not often that you get a real winner, but you got to have the passion.
I also train story consultants. I am also a story consultant. Can people come to you to create a template for all their story consulting clients that
Yeah, absolutely. Yeah. So we do drafting all the time. Nowadays, lawyers are starting to shift a little bit, at least especially in our industry, where it's not only just, hourly rate models anymore, where sometimes for film productions, one, there's like a full production bundle. So you essentially do the legal for all of that. And then we also do just like flat fees for specific types of agreements. So whether it's a one-off agreement or like a template agreement, we do those all the time.
Oh, great. That's wonderful to hear. I should come to you for that alone. What if a Canadian writer sells to someone in the US? Is it more beneficial for them to get a lawyer in the US, or can they work with a Canadian firm like yours?
They can work with a Canadian firm is a good question. So for us to be able to act, we have to have just some sort of connection to Canada. So if you're a Canadian writer, then we're good to go. Similarly, if it's an American writer being hired by a Canadian producer, we're good to go. But US to US or UK to UK transactions and so on, it's technically out of our jurisdiction to be able to act. Again, that being said, there are other people that, are a bit looser with the rules. Again, in the US, they're often open to working with solely Canadian matters. So it varies, but technically speaking, we need a Canadian element to be able to operate.
That makes sense.
I will say, like, if it's a contract, governed by California law or New York law, we like agreements are quite similar, like one to one almost, but they'll still say that they're governed by like New York law or California law if it's a producer based there, and we can't really advise on those specific elements that are specific to that jurisdiction.
Ah, okay, that's good to know. You were saying that it's not so much an hourly model anymore. What are some of the ways people can engage you? Is it like retainer model, or something else?
Again, this will vary law firm to law firm. I can't speak to other law firms, but generally, like our firm, we just operate on like when we provide a legal service, that's when we would provide an invoice. So we don't just, ask for like monthly retainers in and out, even if no services are being provided.
Oh, that's handy. That's good. One time I hired an entertainment lawyer. She was very good. She's not in the business anymore. She asked for a retainer up front because we didn't know how long how long the work would take, but
Yeah.
it seemed fair, right? That seems normal.
Yeah, that's very much normal. I mean, what I was referring to is when you refill the retainer like every single month.
Is it true that you cannot copyright an idea, only the iteration of the concept, for example, in screenplay format? And then if it is that, can you also copyright like a synopsis or a treatment or a log line?
Yeah, so it's correct. So all this is based on like the Copyright Act, which is, the federal statute that governs copyright law in Canada. It generally applies elsewhere too. Ideas are not copyrightable. So you might have a screenplay completely sorted out, even every word that remains in your mind. It's not protected at all. It's only protected once you actually fix it in a form, which means you record it in a way. So you can type it out, you can write it by hand. As soon as you do that, it becomes copyrightable. And the caveat is that it has to be an original work. So it can't be, pulling from existing works. It has to be fully original, and it requires more than, like a transient application of the human mind. So again, that applies to the whole AI conversation, but that's what requires work to be copyrightable. And on that note as well, one misconception is that registering the copyright does not create the copyright itself. So registering it really just creates kind of like an evidentiary footprint that's put out to the world to say like I'm the copyright owner, but it doesn't actually create anything. It's really just registering it, which is a very, very common misconception. You become a copyright owner just as soon as you meet the requirements that you fix it in a form and then it's an original work.
In my understanding, in Canada, the law is that it's copywritten at the moment of creation, as long as we can prove that, right? But in the US, it's different, right?
It's pretty much the same. But yeah, to go back to your original question, yes, your screenplay therefore is copyrightable, your synopsis is, your log line, everything is copyrightable as long as it meets those requirements.
Oh, I didn't realize the log line was okay, because there's a great book out there called and here's the kicker, and it gives the log line to 22 different creators, and they all had 22 different iterations of how they would execute it. It's
Mhm.
basically something I talk about when people are afraid to say, this is my concept. I'm afraid someone's going to steal it from a log
Yeah.
line.
Again, it's a matter of, how general or how specific your log line is. If it's a general statement, then it wouldn't in and of itself be original. So that's the whole thing about a log line is it's not very specific. So if it's too general of a log line, then it's arguably not copyrightable.
And it's true. I didn't have any preliminary questions about AI, but of course it's affecting us all. And you said the human mind has to be involved because people use AI to brainstorm and to,
Yeah.
I guess to check their work sometimes or whatever. So, I mean, you're involved in that process if you're working with AI. But yeah, how can we prove it?
How can we prove that it's AI generated or not?
Or not? Yeah.
It's a good question. From my understanding, there are actually programs now that are AI programs that you can run other works through it, and it can identify with pretty high accuracy if something was generated by AI or not.
And where are we with the laws? I can't keep up with the laws on AI. We have some degree of protection as Canadian writers, right?
So things are still quite in flux. The real question is things are not certain whether so there's a couple different elements here, and this is a full other discussion, so I won't get into it with too much depth today. But one question is whether things generated by AI are copyrightable itself. And generally speaking, the answer has been no. Again, this does change slightly jurisdiction to jurisdiction. But again, in Canada, the rule is that a work requires to have been utilized. I think the phrasing is more than a mechanical process, something like that. So it requires a degree of intellectual capacity. And so again, the program, when it's just running through a mechanized process, it doesn't meet that threshold. So that's the first question. And the second question is that when you use these programs, who is the owner? If we assume that these things can be copyrighted, who is the owner? Is it the AI owners, the owners of the AI generative program? Is it the user? Is it the program itself? So these are all novel questions that we are still kind of figuring out day to day.
Oh my goodness. Oh, and this is a big one too. For some reason, I'm getting like a big influx of novelists who are and deciding to, and this has been like the past 5 years. I've been getting a lot of novelists who say they either want to hire a screenwriter to adapt their book, or they want to adapt their book themselves. But there's a scam I ran across. I think it's a scam I ran across. Someone cold emailed me and said, hey, this company in the States has offered to adapt my book to a screenplay, but they want me to pay $80,000.
Mhm.
I explained to him that it's his property and, producers take a risk to help develop material and that you should be paid something for the option and negotiate and everything. I told him to call a lawyer, but are you seeing scams like this?
I haven't seen that one specifically, but unfortunately, I am seeing more and more just in the publishing world in general, where it is, variations of what they call hybrid publishers or even predatory publishers, where, they're moving from the traditional model of, providing an advance and they then take on the publishing duties. And these entities are kind of similar to what you're saying, are asking for excessive amounts of money to publish someone's book. And oftentimes they kind of disappear after they've received payment. They don't actually publish, or it's like a very basic publishing that goes on Amazon, but really they kind of go and disappear into the world once they've received their payment.
Oh, I thought you were going to say they write into the contract that they get the film rights.
No, I haven't seen that. Well, again, people try to obtain as many rights as they can, but these ones that I've specifically seen, they really are just looking for that service payment and then they disappear. Because everyone, a lot of people want to be published out there, and so it's hard to get a traditional publishing deal. So these people are being pitched by these whatever entities to publish their books, and they kind of ask for very high uh, costs, and then they again don't really do much after.
Do you have any advice for screenwriters in relation to entertainment law that we haven't even talked about yet?
Consider like what are your long-term goals? Like what would you like to do not only like in this moment with the work, but in the long run. So there's certain things that people also don't consider, like whether you could be carried on as a screenwriter on the production itself. Because as we know, if you sell a screenplay, chances are your screenplay is not going to end up as is in the film. There's going to go through further rounds of revisions. So, you could be carried on as an actual writer on set, for which you could be additionally compensated. Retaining certain rights to again have a bit more leverage later on if your property has the potential for sequels or other derivative productions that you maintain some level of control over it just so you can carry on with it moving forward and you don't just lose those rights or things come to a stop like right at the moment of signing the agreement.
Yeah, that is actually a big one. I've seen people get caught in that where their idea is so original and so unique to them, and the agreement still like writes them out of the future of it.
Yeah, even like creative consultation too, those types of rights. Another thing that jumps to mind that's a bit of a separate point completely is that if you're a screenwriter and you're working like in a writer's room, like you've actually been hired as a studio, to keep in mind that oftentimes, your job at that point is writing. So you've been employed to be a writer. The one exception to copyright law, normally if you're a writer or you're someone creating something, you are the copyright owner, you're the author according to the Copyright Act. The exception is in the course of employment. So if you're employed by someone, make sure like you're not working on your own projects during work time because your employer could technically take over the copyright and become the owner of that work because you're writing in the course of your employment. And it's, you got to be very careful there.
Thank you so much, by the way. This has been so enlightening. Okay, wow, there's a lot in the chat. A lot of people from Vancouver. I was going to ask the question too about shopping free or $1 versus paid options. Oh, are you seeing like weird amounts for those kinds of agreements?
I have seen that. The $0, $1 is, yeah, I definitely see it. The $0 you have to be careful with just because technically you do need some semblance of consideration going in each direction for it to be a legal contract. On that similar note, in contracts, you'll often see, the sufficiency of whatever language that sometimes they'll say receipt of. So that actually means that you've received the money when almost every time you actually haven't. So look out for the word receipt in contracts because may as well take it out. But yeah, the $1 again, the $1 is essentially it's a nominal amount. It's essentially nothing that you're just providing it in order to have a valid contract. I do see that quite often, and I think it's fine in certain situations. Again, you might be working with a friend, you're the writer, and your friend is the producer, or something where there's a working relationship, there's a long-standing relationship where you're just trying to get a project off the grounds. I am more hesitant when it's, someone who's pitched you or it's an actual, producer that you've just met for the first time. I would often push back there because there isn't really a reason for them not to be offering you anything. Again, as we've said before, a percentage of revenue down the line often doesn't happen in this industry. So for you to be compensated, it may as well be upfront.
Yes, I've had that moment where someone slid like a loony across the table and said,
Yeah.
"This contract is now legally binding." Yeah,
Yeah.
I had agreed to the loony. What is going on in the producer's mind when it comes to taking the low-cost shopping agreement versus the option, which may have a fee?
Yeah, I'm not too sure about that one. I'm not sure who's asked it, but maybe they could provide a little bit more context.
Oh, it's Ronald. He's a producer. So it's less commitment, but I guess it's also less benefit down the line, right? It's was in the days when like pilot season was a thing and they wanted to come in with 30 projects and have some sort of piece of paper, is what I think, but I don't know.
Yeah, there is really just two different like strategies, two different setups. Like the low cost shopping agreement is really just to get rights to, shop things around. Versus an option, it just sounds like there's more weight to it. They're just different scenarios. There isn't really a versus in my mind. They're based on different scenarios.
I think some writers will only agree to shopping agreements up front because it's shorter terms in my experience. It's been like 6 months to a year, maybe at the most, but it's usually much shorter terms just to get them into it's just just what I've seen. And for international projects, do you need a specific type of lawyer, or should you have a lawyer in the country of origin? You basically answered that one too.
Yeah, and just for context there, to go one step further, yes, you should get a lawyer like in your jurisdiction, so wherever you live. But often for, like treaty productions, it might be a Canada, UK production, you would want to consult with a lawyer, likely in both jurisdictions.
I understand in Canada, if a new writer creator gets an episodic series optioned by a reputable production company, the company and showrunner will squeeze the writer out as typical practice due to experience level.
Firstly, about the episodic series, again, this sounds like it's based on like a situation that you know of. It's not necessarily a rule of thumb, but again, something there is that can all be prevented based on like the agreement that was signed. You could get a contract in place that guarantees the writer, whatever role on a long-standing basis. So that's again why I kind of go back to my previous statement saying, what are your intentions going forward? Make sure you have a lawyer that can translate that to the agreement, because a contract could prevent someone from being squeezed out, or just from, in other words, being fired.
Good. Ronald, do you want to on audio elaborate on what you wanted to ask?
Hi. First, thank you, Daniela and Michael, for coming out for this, setting it up.
Pleasure.
Regarding the production company question about the writers, actually, in Canada, a lot of the broadcasters, when they engage a production company, they also want a reputable, well-known showrunner. If the person who's the creator or the writer is not experienced, that's a
Yeah.
huge risk. So I've heard many times, and after talking to some of the production companies that are making shows on air today, they will pretty much put the new writer sort of in the corner, if you know what I mean. Just because otherwise they won't be able to get the show made or finance from the broadcaster.
Yeah, absolutely. You're absolutely correct there that, it might be a hard thing to sell, but that again is separate to the point that a writer can still advocate for themselves and get certain protections built into the contract. It may just lead to difficulties, but that's not to say that they shouldn't still attempt it.
I
Oh,
think all writers should to do whatever they can in their agreement to stay
Yeah.
with the show as long as you can and as high as you can. Put yourself in the writer's room.
with this showrunner question, yeah, the writers are, I think it's a really high expectation for a new writer to say, I'm staying on as showrunner. I have worked on shows where the writer made deals. So on Suits is famously, Aaron had been a writer for 8 years as a staff writer, as a senior level staff writer, but had never been a showrunner. And the deal he made, they attached a showrunner even to him. And he's not what I would call new, but he wasn't a seasoned showrunner either. And then after season one, he got to take over. So that was like something something he negotiated for. So I don't think it would be a normal expectation to go, I'm a new writer, I'm a first-time writer, I will absolutely not work with a showrunner. You're going to probably be paired with a showrunner, and you'll have a credit of some kind, co-creator. They'll even take away the full creator credit at that point, probably, right?
Yeah, and we were seeing a couple years ago, it's not as much now, but there were definitely shows out there that it was, the showrunner was almost like first time or second time like writers. And those productions kind of went up in flames a little bit, but now with everyone tightening down quite a bit, you're probably not going to see that because the studios are much less or much more risk averse. So again, you're not going to put the show in the hands of a newer writer, but again, anything is really possible. It all depends on what you negotiate and what you have in place to protect yourself.
Is there how do I put this? Like, do you have an ideal client? Meaning, do you have an ideal way you like to work with your clients? Or is it, I guess everyone's different. Like what might be considered bad behavior, I guess is my question.
Yeah, no, it's a very good question. I would say one is, uncommunicativeness. So, being very slow on responding to things that, in tandem with that is if, things are thrown my way that are, due like in an hour or the next day with very little warning. And similarly, if someone kind of goes radio silence for a month and then suddenly chimes in and says, I need this done by tomorrow. So a lot of it is just, respect for one another, making sure that expectations are set and, being open to communication. How I operate is, there's a lot of transparency. So, if I have a busy workload, I often let clients know in case work comes, just so expectations are there. Similarly with like fees and so on, I'm pretty open with conversations there. I don't ever like to surprise clients with, invoices. So there's a lot of foresight and just open communication there. But yeah, just being clear with communications, making sure that our clients are educated as well, so that, they're not going in blind and solely just relying on us, that they're also, understanding what's happening on both ends and, are part of the conversation. And similarly, that a client doesn't just like throw something our way and just so that, like deal with it, or, we want to make sure that again, we're communicating because, we also need express instructions in order to be able to do our work.
That's great. Joyce says, if copyright is created as soon as you put something in writing, what's the best way to prove that creation time?
Yeah, it's a good question. So, this is for some of you who may remember from writing back in the day, this is why people would often, mail themselves their screenplays, that they would put in a sealed envelope and, stamp it and send it to themselves. So they have this kind of marker of date and time for when they created their work, or to show that, to prove that they were the actual author. Nowadays, though, that, when you work with software, whether it's like Final Draft or Word or whatever, we have so much technology now, and like the microdata that says, when you saved it, the time and date, that it's not as worrisome anymore. So we have a lot of that kind of technology. I don't imagine if anyone is, writing a screenplay by hand. I could be wrong, in a notebook, but just try to create some sort of footprint for yourself to show that, you're the author. But things are a little bit more concrete nowadays, in terms of at least date and time.
Ron says, thanks, guys. One more question. Do you think we should retain the paper copies of agreements and contracts that we accumulate and scan, or is retaining the digital copy the best practice?
Digital is totally fine. I would just make sure that, you're using some proper software instead of just like dropping your, what do you call it? A clip art of your signature, something that you use like a proper like signature software that again dates and times when you provide signatures, and then it also locks the documents, so that's important. Similarly, when you're going back and forth, it's always good to provide PDF copies, because again, if you provide a contract to someone and it's in Word, they can, make revisions without you knowing. So, just be careful with that. But no, there's definitely no need for paper copies, I wouldn't say, if it's properly saved on your computer.
Okay, great. Thank you to everyone who's tuning in on YouTube. If you did enjoy this content, please do like and subscribe to my channel. I do have a screenwriting playlist, which covers a lot of topics. Thank you so much, Michael. Really, really appreciate you. And I'm glad we did this. Thank you.
Yeah, thanks for having me today. It was a lot of fun. And if you didn't have my email already, I think we can provide it. And if you ever have any questions, please do reach out. I'm always around.
Great. I'm going to put your contact info and bio underneath the YouTube video. Thank you.
Thanks, everyone.